Hi, is the sound better? Uh-oh. I feel like I just heard a little echo. Okay. I don't know, man. My computer is all kinds of doing crazy stuff. Okay, yay. I'm so happy to hear that. I'm so happy to hear that. I did mess up my mic earlier, though. I decided I was gonna, like, take things apart. Terrible plan. Now it's just completely messed up. Okay. I'm not even gonna open the stream in another. Maybe I will. Okay, so I was going to play some of this, what do you call it? You know, the hearing. Okay, sorry about that. Um, because I was going to talk about it, but now I'm really afraid that we're going to have the same issues, and I really don't want that. So, yeah, I don't know what was happening. So in StreamYard, if you've ever done StreamYard before, no, I don't think I can. No, so you know how Dolly, hi, Wendy. Thank you. That's so nice. Um, but you know, like when you're in StreamYard and it says like present this screen. Well, so I did that. However, instead of it coming up with, well, it did add like the screen I wanted to share, but it also added two of me and it like would not let me delete the other one of me. And I kept like leaving and coming back in and it would still wanted to hate on me. So I really, I just don't know, guys. I just don't know. But that was terrible. And I apologize in advance. Let's go ahead and get rid of that. Now, hopefully, I'm just supposed to put share entire screen. You know, Dolly, I'm not sure if there were or not because one of them just wasn't showing up until because I had my like screen minimized, so I couldn't see the whole thing. But there might have been two of me. Yeah, and I got this roadcaster, and it has really created more problems than are necessary. But I do have something cool that y'all might be able to hear. Ooh, that was really loud. That was also very loud. See if I ever said anything funny, we could use that. Huh. It'd be real cute. Okay. Uh, if y'all could hear it, you might not have even been able to hear it. Okay, so anywho, today we're gonna try this whole Becky Hill thing, or Alex Murdaugh. Really, it's Alex Murdaugh, but you know, because of Becky Hill. So I'm sure that y'all all know that I don't agree with the results of the hearing, but I'm not the judge, so that doesn't matter. The Becky Hill thing. Um, yeah, so I'm not the judge, so it really doesn't matter what I think about what uh, the standard should have been, but it is what it is. Yes, cheers. Cheers, paralegal Liz. Oh, y'all did hear it? Yay! It was a little loud, huh? feel like there's feedback. I don't know if that's really what you call it. Now I'm acting like I'm an audio engineer, which I am not. Okay, so anywho, let's listen to what Mr. Creighton Waters has to say. I think this is the part about the standard. But as you can see, I have like 8 million screens open. Oh, y'all can't even see. So just kidding. No, you can't. But I have a bunch. Yeah, we definitely need view. Hi, Becca. Becca Lynn. I know. It's still so far away though, right? I feel like it might not be fantastic. It might be not fantastic. So, you know, I've lost less sleep about it recently. No, I've never lost sleep. I don't think. Okay, so I think this is where Creighton's going to talk to the, yeah. Wait, who's fabulous? Okay, let's see here. Let's make sure that we don't screw this up this time. Okay, now let's go over here. Nope, that's not what I want to do. Nope, that's not what I want to do. Just like make you bigger, you know, like bigger.
Clearly external information, and again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state court of appeals, is clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice, and that's of course only after there's a determination that any sort of extraneous influence occurred, and that would be the state's position that it is the defendant's burden. And again, we can address at the appropriate time what the state position is as to the order which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, in reply?
Yes, Your Honor. There is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten a pamphlet, voir dire to every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accusers, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green said it was a procedural communication, not a merits communication. And Your Honor, in Bryant, well, I wouldn't know, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to what they believe in the death penalty. Apparently, that's some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question, it has to be established, but the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, And the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? You know, I'm not going to go back and forth.
Ooh. Okay. I know there's a vacuum going in the background. I hope it's not crazy. Hey, Farrell. Where's who? Oh, where am I? No, you can't even hear me. Could y'all hear me? Or could you not hear me? Can you hear me now? Can't hear me. What the actual fuck, man? Yeah, I know the video's not playing, but can you hear me? Okay, you can hear me. Well, okay, when I pushed the, I don't even, okay. Anyway, so that was them talking about which standard should be used, right? We're going to continue to play. Tell me the next time something goes wrong.
Your time, sir, if you want to have a short comment and additional thought.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly all of those were external influence cases, Your Honor.
All right. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis of after-discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry is the procedural argument of the State that this matter was untimely made.
Oh yeah, that's stupid.
Mr. Waters?
Yes, ma'am, Your Honor. And again, we have...
Okay, I don't really care about that part too much. I mean, we can listen to it. We'll go back and listen to it. But I think that MG Law, hi. I think that he brought up all the valid points here. That the other cases that she's choosing to use as the standard are cases that involved juror misconduct, not like misconduct by a courtroom official or actor, on behalf of the court, state government actor, whatever. What she said. How can she? I don't know. Is that what the federal law said, that the bailiff can speak with the jurors, not the clerk? Wait, what did KLI say? Oh, I don't know about that part. But I do think that she got it wrong, because the case law that the defense cited said that as long as the clerk, as long as you show that the clerk had inappropriate contact with the jurors, then you get a new trial, right? Then the prejudice is presumed, and then it's the state's burden to disprove it, I guess. Man, that sounds so terrible. Do y'all hear that? Like, it's the worst. I think it's because it's turned up so high. Okay, we're gonna play.
Raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing, and there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan of procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me...
Bye, Flash Fan. Thank you for coming. It was so good to see you. I mean, I wish I could say I understood all these big words at the moment, but I think I fried my brain with the audio earlier, and I'm just going to say, okay, whatever you say. Okay. Is it Pooty's turn? Okay. Oh, good.
Say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
All right.
Oh, boy.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree.
Probably, Mags. I don't even know what that means, but I'm sure they have it. Let's see here, bud. Should we do, I'm not sure that works. Maybe this will be better. Maybe this will be better. I don't know. I don't really know what it is, but I just pushed some buttons, so we'll see.
Your Honor, it's a question of jurors. The only question is, I mean, not the only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions we, after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed, maybe 2 have not been interviewed by SLED and given statements, recorded statements. The rest have all given recorded statements. And then SLED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask,
Oh yeah, I don't trust SLED at all.
the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. I mean, there's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused, the alternate because she wasn't needed, the egg lady because the judge found that she had had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined.
Yeah, I don't feel like listening to all of his argument. Seaboat case. Oh yeah, right? Sorry. Didn't mean to do that. Yeah, Matt, I really I don't think you were here at the beginning of the stream, or the last stream, I should say, but I really screwed up the audio to a point where I think it would be wise for me to just not touch anything because it was crazy and I had to end the stream. And I'm about to pull this thing out of the wall. I mean, you know, welcome to my day. Also had kidney stones the whole weekend. So there's that. Okay. Let's see here. Where was the next place I wanted to go? I think one.
The nature of the inquiry that needs to proceed from there. And at that point, the state would, take the positions that I've outlined here today.
Oh, we don't care, Creighton. Shut up.
You reply.
Please, Court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I noticed would be surprising to Mr. Waters, is motive.
Okay. It's ironic because it's 404, which is prior bad acts, which obviously Creighton loves getting those in. That kind of evidence in, right? That's basically Alex's whole case was 404. But they are trying to get this in. Oh, hey. Hey. You know you can get on here if you want. I mean, you probably don't want, but if you want, you can. You know how. Oh, you didn't really miss anything. Nothing. I mean, you've seen this before, right, Dave? I turned the heat on again, and it is way too hot. Anyway, the state is saying 404 shouldn't come in regarding Becky, and Harpootlian's saying it should come in to prove motive. So the reason behind her having this improper contact with, yeah, it is pretty ironic that they're like, no, 404 is so important to keep stuff out. The state. But not all of it. Not all of what? They don't want to keep all the 404 out? I feel like they want to keep all the 404 out regarding Bex. I shouldn't say that. I call my daughter that. I don't want to associate the two. Oh, hey, Christine. Okay. I'm going to play this. Oh, okay. Well, so far they've been arguing about the standard. And a little too ironic.
As if he'd never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So.
Okay, and here's the thing. She's going to say, like, this book thing, you know, shut up about it. Stop talking about that in my court, sir. I mean, shouldn't exactly say it like that, but basically. And obviously, it's not just Harpootlian that thinks it's important because the state just told him about it this morning, right? What? I missed that. I mean, I heard about a stream on Vice's channel. Like, I heard about it from many different outlets, I guess you would say. Was this the Friday? Is it like a Friday night stream or a Saturday night stream or something? I'm gonna have to go back and watch. I don't remember what I was saying. I got distracted by Danielle in a bikini. Okay, yeah. The F It Friday stream. Okay, I'm gonna go back and watch that. I heard it got all kinds of crazy. All kinds of crazy.
We believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies.
Oh yeah, that's what I was gonna say. I think Creighton thought it was important too because he told him just this morning that this happened. That somebody said, Becky told me that a guilty verdict would be good for book sales, like before the guilty verdict happened, which obviously gets into motive.
To call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for your honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest?
Okay, I would just like to apologize to Danielle because apparently MLS is over here making replies. Oh. Okay, I'm not putting that one up. Okay. Y'all are the worst, and I'm gullible.
To you a further question. because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom and have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you.
Oh, she's so loud, man. Her paper. Was this before she decided the standard, or was it after? Because it's weird to me they start arguing for the jurors don't have anonymity anyway.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors.
For real?
And I will notify the parties pretty promptly what I intend to ask.
Can you hear me now? Can you hear me now? Oh, you know why? Because I decided I was going to be so smart and go change the audio, which is a bad idea. Right? Yes, this is a female judge. And yes, it was hard to know that, MG. Okay, yeah, I'll start pausing. I'll start pausing. That was yuck. That's real loud. Also, there's so much ick on these headphones. Or monitor. I don't know what you call them.
The jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics, her personality, or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions
I think it does need some explaining, Baker. Oh, did that happen in the treehouse case today at some point? I feel like it must have, because y'all ended super early today. Everybody did, I think, right? That was doing that case. And I couldn't figure out why. I mean, granted, I also didn't watch, but that's because I was sleeping.
initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not
Right? And if he just found this legal loophole, why didn't he just file it like right away? Yeah, it doesn't stop the case though. So it's just a brief pause, if you will, I guess. Just a little pausey pause.
time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process.
See, I thought that was super weird because I don't think anybody... Okay, so he is out on bail. Okay, not Alec. I'm sorry. I should stop commenting on that other case or it's going to get really confusing. But the treehouse guy is out on bail. But I don't think anybody said they wanted thousands of emails to come in. I think the defense was planning on using like 2 emails, I think. Right? So that's crazy. That she's like, I can't imagine thousands of emails. Well, nobody said thousands.
Emails sent by her to attorneys in the case.
Alec did not like that.
To other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical, dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore.
Okay, so she said that the only things that they're going to be looking at are, did the clerk have contact? Was it improper? And did it affect their verdict? That did it affect their verdict part is the part that is a problem for me. But it essentially affects everything that comes after that, right? Yeah. Also, it's like super hard, especially in these circumstances, which we'll talk a little bit about it a little later, but it is super hard to get a juror to say that anything affected their verdict or that they weren't able to be fair or follow the law. It's a big problem.
That I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proper, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have a hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I rule that they're not properly used. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made and the filings you made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not.
Yes, Matt. She's saying that it is the so it's his burden to prove that it did affect the verdict. So there's that. It's a big problem. Big problem for him.
Not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. And when I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by proceeding in the way I've just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor. Thank you, Your Honor.
You're going to take a break too. I don't remember this break during the like actual hearing. And then what did he say? Yeah. Wait, why would that be bad if they let Poot question the jurors? Or Becky? I mean, bad. Bad. I feel like that would be fantastic. Not the jurors necessarily, but I would love to see him. You do not have time for what? What are you talking about? What do you mean your haircut? Are you trying to get a haircut? Apparently, it does not make a difference. Oh, I feel like she should have gotten it at this date. Okay, I don't remember this break, but I'll try to see. It looks like they just come back and they're just like chitty chatting, right? Oh, I should push play. Just chitty chatty, chitty chatty. More chitty chatty.
The trial judge, that alternate did not.
Just kidding.
The jurors.
Look at me. Like I know what I'm doing. You are too, guy from Hampton? Okay. Wait, why?
The things that they will put on the record as we proceed through these topics that deal with what should be covered.
Oh, Dave.
The first topic.
Why'd you tell me to do this?
Before we proceed further, a few other things that you've asked about that I want to clarify before we then go forward with a more specific look at how witnesses will be questioned. First of all, how the jurors will be questioned. Everything will be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for the jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the
Yes, kind of. That's kind of how I see it. Hi, guy from Hampton. Although I heard the other day, like, I know your name's not the same, but I feel like I heard where you're, like, not supposed to say that sort of name on stream. I have no idea, but I'm saying it anyway. Yes, kind of mad. This is true. But it's a different judge. But yeah, I mean, you know, still the court.
The judge's request, and I'm very confident there will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case, and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that.
Will not permit that. But yeah, okay, so this makes sense though. If she is using the standard that they have to show that it prejudiced the verdict, well, if they didn't sit on the actual, if they weren't like deciding the verdict because they were kicked off like a day before or earlier that day or whenever it happened, then yeah, it's not going to be relevant to did it affect the verdict, right? So it makes sense once she's already decided what the standard's going to be, then she just, all the rest of the decisions follow.
With witnesses or testimony I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as the proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the party should submit.
I do agree with you, Farrell. Oh, hey, Eris. I totally agree with you, but I mean, I get that argument too. I was about to make it like, well, but if they hadn't have been kicked off the jury, it could have affected the verdict. And also, earlier, Poot was trying to get into why they think she was actually kicked off the jury, which was that she had gotten word that this woman was going to vote not guilty, right? So that's a problem. But since the judge decided that it's only whether or not it affected the verdict, since that person didn't deliberate, it couldn't have affected the verdict. But I get your point. I get it. I do get it. It's a silly decision, I think. Okay, let's push play.
Subpoena these witnesses, and when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no juror should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and that when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was completed, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that, and that's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be the overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings. If there's not enough room, based on the attendance today, it might be plenty of room. We'll see. We'll have this as, I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I've set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill any other issues that still need to be developed.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors since they were all told this at the same time?
I'm not sure I understand your question, but I'm just telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I'm not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, we can get more detailed affidavits, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, that she made the statement, and two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say, and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to who it said Did I have a question?
Well, Your Honor, we did submit an affidavit. I have no problem going back.
You submitted one alternate affidavit
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So,
And that doesn't prompt me to change what I just said to you.
well, we can get you more.
I am so jealous of this. I want to be in that courtroom so badly, but like maybe not, because I feel like it's going to be like a terrible defeat for the defense and for just justice in general. But you are lucky.
More specific, I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may.
Oh yeah, no, it's literally like worthless. No idea why it's so important for them to protect this verdict. Like it's crazy. It's crazy.
You could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them that they, A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage of this building and be escorted up in a private way into their suite.
And that's the issue, Liz. I don't think they're going to. They just aren't going to. Especially since it is now, we know that it's going to be taking place in open court, and that the judge is going to be the one questioning them. I don't know that necessarily not sure if that is going to matter in terms of if they're willing to come out and say that it affected their verdict. The thing is like, they're going to be in open court, so anybody from the community that just wants to come and sit in that courtroom, obviously is able to, and there's not going to be any protection for the juror's identity. So, and it appears, even if it's not like a huge thing in the community, which I would think it is, like this case and this verdict probably was a giant thing in the community, and it seems like if you come from a really small town where everybody knows everybody and people are easily able to identify you, and you come out and you say, yeah, it had it affected my verdict, and then he gets a new trial. You can just go on to like Discord and Reddit and Twitter and all these places and see how much like hate there is out there for this man, and how it's just crazy. It's crazy. And people doxing people all over the place. Can you imagine if you were actually a juror on this case and like what you said mattered? Because I see lots of content creators get a bunch of hate on the internet over this case, or just like people on Twitter based on their opinions, when their opinions have like no bearing on the outcome. Can you imagine for somebody who actually will affect the outcome? So I just don't think that they're really set up to be able to answer that honestly. Maybe. Yeah, I agree with this, except that I think that people might. Okay, so first off, I think one of the main things, it's not that like these jurors are bad necessarily. I mean, also just, I don't think it's not their fault. It's not their fault what was said to them. And they shouldn't be expected to answer that question truthfully, because I don't think that they can even answer that question truthfully. I don't even think they would know if it like not necessarily all the time would they even know if it affected their verdict. You know, if they were hearing this stuff throughout from somebody who they thought was a good person, or somebody who had authority, or you know, knew things in the court, then I'm not sure that they would have ever thought that it affected their verdict, but it still could have, you know? Oh yeah, 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 yeah. Oh yeah. Everybody wants it to go away. Exactly. Well, that's the problem. If everybody wants it to go away, then they want for there not to be a new trial. Can you imagine? Like the juror, if a juror comes in and says, "Oh yeah, this was said to me and it affected my verdict," and then he gets a new trial, like, oh my God, they're going to be hated all over social media. Obviously, we know that for sure. But I would think also in the community, which is super scary, because I'm sure that these people have jobs and kids and, you know, want to continue to live in their community and participate. And they probably don't want to be an outcast. That would be terrible. Right. The jurors probably didn't know. And right again, how could you know? Exactly. Yeah, I agree with that. I mean, I think once it's shown that there was improper contact, that should kind of be the end of the questioning, end of the story. Yeah, that's a good question. That's a good question that I hadn't thought about. I don't know what happens in that situation. Yeah, it won't be on TV, so their faces won't be on TV, but everything else will be on TV. Yeah, they have protection from the mob of, like, you know, people watching on the internet or watching on their televisions or whatever. But but we already know from a lot of cases that this stuff, like, people are easily doxxed. If they're in the courtroom, people from the community are in the courtroom and able to see the actual jurors and know which one said what, they're going to dox that. No doubt about it. They are going to dox it. Yeah, of course they're being told what to say. They're being told what to say in order to protect the verdict. Exactly. You would think it was part of the process. You would have no idea that that person's not supposed to be saying that. They're just supposed to tell me like this is part of it. They're telling me what I need to be on the lookout for, right? And no, it didn't have. But like if you've got somebody just pounding it in your head all the time, how like anti-defense they are, and you think they're like somebody running the trial, which she was for. Uh, just look through her email. Then yeah, that's gonna. I mean, it can't have a great effect on you. Also, I'm super concerned, and nobody else seems to be super concerned about the dude whose brother was law enforcement, who was paid to stay on the jury. I still feel like that's a problem. His friends paid him to stay on the jury. Was it his friends or was it his brother's friends? Because that feels like a problem to me. But I guess they didn't see it as a problem. Maybe it's not a real problem, but seems like a giant problem. So yeah, we know they are going to be questioned by the judge, and it's only going to be the jurors that rendered a verdict, not any other jurors. And the faces will not be broadcast on television. They're going to be referred to by number Oh yeah, of course. I know you're not going to dox. I know you're not going to dox. Of course not, because we don't believe in doxing jurors, because that's crap. They didn't do anything wrong. And they absolutely shouldn't have to deal with the crazy social media trolls. And okay, so those are the only ones that are going to be questioned, and they won't be doing the 404B. Yeah, so anywho, so we're going to get like nothing, and apparently they're going to leave the door open as to whether or not the defense is able. They just look so defeated. Look at them. How do I just change it to this? They look real sad. Real sad. Ew, yuck. How about that? How about that? Catch me outside. How about that? Funny, funny, funny wording, Farrell. I once knew a lawyer that went to jail for saying that. I'm just trying to show these nice people how hard it is to get a fair trial in this court. But don't try that. I don't know. He got a long time for the financial crimes. Like, that, I don't know. I don't even want to say, but I feel like it was more than 40 years. Maybe I'm wrong. Maybe it was like 27. But how old is he? I don't know. I don't know how long he got, but I know it's like a long time based on how old he is. Like, there might be a possibility if it was just the financial crimes. I think of him getting out at some point, but he would be like very elderly. But obviously with this case, he got 2 life sentences, right? So that's a never getting out. Never getting out. Oh. Y'all, could y'all hear me the whole time I was talking, but you couldn't see my face? I bet not. Yeah, he doesn't want that murder on him. And I mean, yeah. I don't even know if they proved that he was there. I mean, I get where a lot of people say that they did prove that he was there. However, I think that they just proved that he was there very shortly before. Like, we know that it happened in a very short amount of time regardless, right? Either he was there when it happened, or he had just left when it happened and he came right back. But them deciding that that's the exact moment that they died because there was no more phone use or whatever is kind of, I mean, it makes sense, but also not. I mean, it does make sense, really, if I'm being honest. So he was likely there, but it also could have been just like a few minutes. Until what? Till I said what was a mistake. I know, I am low compared to court. Is this louder? Also, court's not playing. Right? Anywho. So I am excited to see this uh on Monday. I'm really not excited. I'm actually kind of dreading it, but it is what it is. Also, so we I know it's not playing. What? Oh, okay, I get what you're saying. Yeah, no, I know my voice is super low compared to the court, and I can't figure that out yet. I'm gonna have to get on and look at more like roadcaster stuff. But um something that I might cover soon, it depends. But I have been really obsessed over the weekend with watching all, I don't know if y'all know anything about this, but there's like some Scientology protesting going on. And it's like a movement that's happening, right? And one former Scientologist, I think his name's Aaron Smith Levin or Aaron Levin Smith or something like that. Aaron. Yeah, he was arrested, right? And it was crazy. So crazy that he got arrested. And also then that they just let him go after keeping him hooked up to like a bench in the bathroom, or maybe he didn't actually go into the bathroom, but they considered it. And yeah, it was just crazy. And so I might be covering some of that soon just because I find it super interesting and I'm obsessed with watching those the people that like live stream their protest from in front of the um in front of the, what do you call it? The Scientology centers and places and houses. And yeah, it's just super interesting to watch those channels and then to see how, like, I just don't understand why uh the police department in LA is like, yeah, let me get on board with this. But whatever, yeah, he got arrested, but it doesn't seem like he was charged with anything, which duh, because he didn't do anything. And I think the other guy, I hope the other guy was charged. I heard he was charged with misdemeanor assault, but we will have to see. But regardless, we will be watching on Monday in this case to see what the outcome is. And I know paralegal Liz will be there. We will definitely have to do a show with her after that. I haven't asked her yet, but I will. To see what her thoughts on the case were. I would be super interested to hear about that. And that is it for me today. Turn on your notifications, I guess. Because you know me, I like to tell you like 2 seconds before. I just did what? Oh, yeah, I did just ask her, kind of, huh? But I'm going to ask her like in a private chat or whatever. Not private chat, DM. I don't know what you call it. Yeah. Also, hit the like. And thank you, everybody, so much for being here. And I will see y'all next time. Bye.